Good afternoon. My name is Laura Raisty. I'm an attorney here at Kenny and Sam's. I am joined today by my colleague Rachel Eisenhaure, and today we're going to be discussing issues concerning classification of employees and why it matters. It's of the utmost importance that employers are properly classified as either exempt or non-exempt under the Federal Fair Labor Standards Act in order to ensure that employees are being properly paid all wages due, including overtime. I'm going to be talking about the FLSA, which is the shorthand term for the law, in the second part of the program. The first part of the program is going to cover state law on the difference between independent contractors and employees. It is also vitally important that employers know the legal difference between those two categories of individuals and that they properly classify them as such to avoid potential legal liability. So I'm now going to turn it over to Rachel, who's going to tackle issues concerning classification standards for independent contractors in Massachusetts.
Thank you, Laura. Whether or not an individual is legitimately an independent contractor under Massachusetts law is governed by statute, colloquially known as the ABC test. For an individual to be properly classified as an independent contractor, all factors of the test must be met: A, B, and C. Stated differently, failure to meet any one of the factors means that the individual is not properly classified as an independent contractor. Now, here are the three factors. First, factor one. The individual is free from control and direction in connection with the performance of the service, both under his contract for the performance of the service and in fact. This means that the individual operates with a certain amount of independence and autonomy. According to the Attorney General, an individual is free from control or direction if they complete the job using their own professional approach without instruction, and they dictate the hours that they will work on the job. Let's look at an example. First, this factor is not satisfied where a truck owner-operator hired by an oil company to deliver fuel oil was required to paint his truck with the oil company logo. And the company designated the prices, the customers, and the delivery schedule. Now, on the other hand, this factor was satisfied where adult newspaper carriers did not wear uniforms, did not drive company cars, and were free to make the deliveries in whatever order they chose in their own judgment, and were not permitted to display the company's logo. Factor two. The service is performed outside the usual course of the business of the employer. Perhaps what is in or outside the usual course of an employer's business is one of the most complicated, complex questions with regard to independent contractor classification. For purposes of our discussion today, if the individual is providing a service that's part of a separate and distinct business from that of the employer, this factor is satisfied. Conversely, if the individual is performing a service necessary to the employer's business, they are an employee. Some examples. A drywall company classifies an individual who is installing drywall as an independent contractor. This would be a violation of prong 2 because the individual installing the drywall is performing an essential part of the employer's business. Alternatively, an accounting firm hires an individual to move office furniture. Here, prong 2 is not applicable, although prongs 1 and 3 may be, because the moving of furniture is incidental and not necessary to the accounting firm's business. Now, factor 3. The individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the service provided and being performed. Consider whether the service in question could be viewed as an independent trade or business. For example, is the individual capable of performing the service for anyone who wants it? If so, that weighs towards satisfying this factor. Now, please be aware that under Massachusetts law, the ABC test is applied rigidly, while acknowledging that there are certain circumstances in which individuals are legitimately classified as independent contractors.
It's crucially important that employers in Massachusetts properly classify individuals working for them as either an employee or an independent contractor. It's very easy many times for an employer to bring somebody in, say they're going to be an independent contractor, and 1099 them. If you do that and you do not satisfy the ABC test, you could violate a number of laws with regard to proper classification of employees, because employees get benefits such as health benefits, sick time, etc. Employers also have to withhold employment taxes and things like that from an employee's salary. And if you're classifying someone as an independent contractor just because it's easy, the government's not getting their share of the pie there, and it's also viewed as an employer depriving this individual of certain benefits that go along with employment. Now, if you do misclassify someone as an independent contractor instead of an employee, it can violate one or more of the following laws. Wage and hour law, both federal and state, and that includes minimum wage and overtime law. For example, if you have someone who's an independent contractor that you're paying $5,000 to do a project, that person does that project over the course of a number of months, works over 40 hours in a particular week. If you've misclassified that person is now entitled to overtime for any hours over 40 that they may earn. There's also a law requiring that you keep accurate payroll records. Failure to properly classify an individual as an independent contractor may run you afoul of that law. As I alluded to earlier, there's also a law that requires employers to withhold and pay taxes on employee earnings. Failing to do that because you've classified someone as an independent contractor will raise the eyebrow of the government, both state and federal. And finally, knowingly misclassifying an employee or an individual as an independent contractor when that person should be instead an employee may violate the Workers' Compensation Act, because you're required to offer Workers' Compensation Act to your employees, but not to your independent contractors.
Thanks. It's also important to acknowledge that the enforcement and penalties go along with the classification of independent contractors. Now, the Attorney General, first of all, can impose substantial civil and criminal penalties. This can include, in some circumstances, personal liabilities for officers of the company and others who were involved in the management of the employee. Now, that's important because obviously personal liability is something that one would want to avoid as an employer. Now, misclassified employees also have a private right of action after filing with the AG's office. So as a procedural step, any employee would have to file with the AG's office before pursuing their private right of action. This private right of action could entitle the employee, though, to mandatory triple damages and attorney's fees, and these can add up fast. In summary, it's important, critical for every employer to make sure that its independent contractors are in fact independent contractors under the ABC test. A failure to do so can be costly for the company and potentially those managing the company. Let's turn back now to my colleague Laura to discuss classification under the FLSA.
Thanks, Rachel. So now we're going to talk about who is an exempt employee and who is a non-exempt employee under the Federal Fair Labor Standards Act. Both Massachusetts law and the FLSA require that most employees in the United States be paid at least the minimum wage and overtime at a rate that is not less than 1/2 the regular rate unless there is an applicable exemption. I want to put a pin in that for the moment and make just a general observation about today's program that Rachel and I were discussing this morning while we were preparing. There are a lot of nuances and a lot of exceptions to the laws that we're talking about today. We are speaking today in broad strokes about two very highly litigated areas of the law, and everybody's situation is different. So again, please keep in mind that when we're talking about these principles, we're doing it in keeping in mind that we have a general audience. So we're talking about general principles, and we're trying to do it in a half hour. So you want to keep that in mind when considering these issues. And if you have any question or concern about whether you're classifying somebody properly, either as an independent contractor or as a exempt employee, the lawyers here at Kenny and Sam's are always ready to help you. But again, just wanted to make sure that our audience understands that this is a complicated area of the law, a lot of wrinkles, a lot of nuances, and again, we're talking about it today as a general matter only. So with regard to the Fair Labor Standards Act, non-exempt employees must be paid minimum wage and overtime. These are what people generally consider their hourly workers. The minimum wage, keep in mind that the minimum wage in Massachusetts is much higher than the federal minimum wage. So if you're paying the Massachusetts minimum wage, you are most certainly in compliance with the federal minimum wage requirement. Now, exempt employees do not need to be paid minimum wage and overtime. So we're going to talk about who is exempt under the Fair Labor Standards Act. And for purposes of our discussion today, I'm going to focus on the most common exemptions, which are known as the white-collar exemptions. These are statutory exceptions and other instances in which there are other instances in which the FLSA may not apply that are beyond the scope of our presentation and the time that we have available today. Again, so if you have any questions about that, please feel free to reach out to us. There are two parts of the white-collar exemption test. The first is called the salary basis test. For a white-collar exemption to apply, the employee must be paid at least $684 per week, with some exceptions. Some of these exceptions include outside sales employees, teachers, lawyers, unfortunately for Rachel and I, and doctors. Do not fall into the trap of assuming that just because you're paying somebody a salary that is at least $684 a week, that you have an exempt employee by virtue of that one fact. That is not the case. Just because you have somebody who you consider salaried, that does not mean that they are automatically non-exempt. You need to also look at the duties test. It's the salary test plus the duties test. Each white-collar exemption has its own duties test. We're going to first talk about the executive employee exemption. For this exemption to apply, the employee's primary duty must be managing the enterprise or managing a recognized department within the enterprise. For example, the president of the company, that's someone who's managing the enterprise, but we also have the human resources department, and the head of human resources is managing that customarily recognized department within the company. So both of those folks would satisfy the first prong to be an executive exempt employee. A non-exempt employee under the executive exception. That employee must also customarily and regularly direct the work of at least 2 or more other full-time employees. So look at our head of HR that we were just talking about a moment ago. If that head of HR supervises only one employee, only one full-time employee, and not two or their equivalent, then this exception is not going to apply for that employee. The employee must also have the authority to hire and fire other employees, or their suggestions and recommendations as to the terms and conditions of employment, like hiring, like firing, like promotion, pay, other indicia of status, must be given particular weight. So that is, if you have someone that fits the bill on those three criteria, and again meets the salary basis test, then you can properly classify that person as an exempt executive under the FLSA. Now, just because someone doesn't satisfy the executive exemption doesn't mean that they won't be covered by one of the other exceptions. So even if you as an employer think in your mind, for instance, that our head of HR that we were talking about a moment ago, who supervises only one employee, you think of that employee, you think of that head of HR as an executive. Look at the other exemptions that we're going to talk about, because they might also apply. Because as I said earlier, the fact that she supervises just one employee will mean that she doesn't pass the executive exemption test. So let's look at some of the other tests that we have. Administrative employees. This is another exception under the FLSA where you can classify somebody as non-exempt. And again, at the risk of repeating myself over and over again, they must also pass the salary basis test in addition to the duties test. For this exemption, the employee's primary duty must be the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customer. This is someone, for instance, an office manager who might supervise a staff of 4 other folks. Let me back up. Your office manager need not supervise anybody, actually. So let's take that out of the equation. If you have an office manager, that person could be considered an administrative exemption as so long as they're performing office or non-manual work directly related to the management and the general business operations. The primary duty must also include the exercise of discretion and independent judgment with respect to matters of significance. There is some wiggle room here. What is exactly the exercise of independent judgment? What exactly is a matter of significance? I would venture to say that, ordering lunch is not going to be a matter of significance. This is someone who is involved in making day-to-day decisions using their professional and independent judgments on things that matter to the bottom line of the business. If you have someone who passes those two tests, those two factors, then you may have someone who is exempt under the administrative exception. And again, because I gave a bad example at the beginning, I want to be clear that to satisfy the administrative exemption, you need not supervise any employees. Next is learned professional employees. And in this, the employee must have a learned degree and is again exercising discretion and independent judgment with regard to matters of significance. These are people like lawyers, doctors, people who have advanced professional degrees and are performing in that capacity. And I'll now turn it over to Rachel to discuss 2 more of our white-collar exceptions.
Thank you. So the next exemption is for computer-related occupations. For this exemption to apply, the employee must be employed as a computer systems analyst, a computer programmer, software engineer, or other similarly skilled worker in the computer field, performing particularly with computer systems, programming, or application duties. Now the next exemption is the outside sales exemption. For this exemption to apply, the employee's primary duty must be making sales, as defined in the FLSA, or obtaining orders and contracts for services or for the use of facilities for which consideration will be paid by the client or customer. In addition to this, the employee must be customarily and regularly engaged away from the employer's place or places of business. So, salespeople who work within the employer's place of business do not qualify for this exemption. This is an outside sales exemption for salespeople outside the employer's place of business. Now, another interesting factor about this exemption is that you will recall Laura said at the beginning that there are some white-collar exemptions for which the salary basis test of $684 a week does not apply. This outside sales exemption is one of those exemptions to which the salary basis test does not apply.
Thanks, Rachel. I'd like to go back and just briefly revisit the learned professional employees example, because I think I gave it short shrift somewhat by just saying it's doctors and lawyers, etc. Again, a learned professional needs to satisfy the salary basis test, but then they must perform as their primary duty work requiring advanced knowledge in science or learning, defined as work predominantly intellectual in nature. And they must acquire that knowledge through a specific long-term course of study. And again, as I said earlier, must be demonstrating good judgment and discretion. So I think I lumped it in a little bit with the administrative employees and wanted to be clear that that is in fact its own exception with its own tests. If you fail to properly classify your employee as non-exempt, you may be liable for damages under state wage and hour law, which, as Rachel previously discussed, includes mandatory triple damages and attorney's fees. And this is something that we talk to our clients about a lot when they're faced with classification issues and wage and hour issues, is both of those add up fast. Triple damages and attorney's fees can sometimes at the end of the day in these litigations end up being the lion's share, or certainly are the lion's share of the potential liability. Under the federal law, the FLSA, in addition to the unpaid wages themselves, liquidated damages are available in an amount equal to those of the unpaid wages, as are attorney's fees. And then finally, employers who willfully and repeatedly misclassify their employees as exempt when they are not may be subject to civil penalties and may actually be criminally prosecuted.
As you may have gathered, proper classification of employees is a thorny issue, and there is no one-size-fits-all. But it is of the utmost importance to make sure that your employees are properly classified to avoid the draconian and expensive consequences of failing to do so, including those triple damages, attorney's fees, potentially personal liability. Again, if you have any concerns about whether your employees are properly classified, please do not hesitate to reach out to Kenny and Sam's for advice and counsel.
Thanks again for joining Rachel and I today. We are fully cognizant that we threw a lot of information at you, and we're grateful that you spent some of your lunch hour with us today. Any questions, please feel free to reach out to either one of us or any other Kenny and Sam's attorney. We're always happy to help. And again, I will reiterate what I said earlier in the program. This was a broad strokes discussion, so please keep that in mind. I'd like to ask you all to mark your calendar for October 20th for the next webinar in our firm's construction law series entitled Getting Out of a Bad Contract. And next in the employment law series will be a seminar on November 9th, 2022 at 12 noon when our colleagues Greg Vanden Eykel and Brittany Darcy will be discussing the Massachusetts paid family and medical leave. Thank you so much for joining us today.